Howdy there, civic students. Today we're going to talk about Amendments 4, 5, 6, 7, and 8 to the United States Constitution. These amendments restrict the government's power to investigate and prosecute and punish crimes. And you might think, well, aren't those things we want the government to do? Isn't that part of the government's job? And of course the answer is yes, that is an important part of the government's job, but these powers are easily abused. And these amendments to the Constitution were put in place to help prevent the government from abusing these powers. How might the government abuse these powers? Well, let's just say that we have Mayor Bozo, and Mayor Bozo is kind of unscrupulous, and it's an election's coming up, and there is someone who's running against him to hopefully become the new mayor. And so maybe Mayor Bozo talks to his pal down at the police department and says, hey, pal at the police department, how about if you go arrest my opponent here who's going to be running against me in the election? And just like make up a reason. It doesn't really matter. Just go and arrest him, whatever. And throw him in jail. And we'll make up stuff, and yeah, that way he'll be in jail, and then maybe I'll win the election. Yay, me! Okay, well, obviously that's not the kind of thing that you want happening. That's the kind of thing that can happen when the government has too much power to investigate and prosecute and punish crimes. And you do see governments doing these kinds of things sometimes. It's not that uncommon in some countries, unfortunately. But here in the United States, that thing doesn't happen as much. Of course, people still do stuff they're not supposed to do. Corruption is a real thing sometimes. But in our country, these things don't happen as much as they might otherwise because of Amendments 4, 5, 6, 7, and 8. So let's take a look at these amendments. Let's start with the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. What's this mean? Well, first off, it means that any searches or seizures must be reasonable. Well, what's reasonable? That's a good question, and obviously there's going to be some debate about that. But generally speaking, that means that police officers and other law enforcement officials of the government may not just willy-nilly go around snooping through things and taking stuff or arresting people without having an awfully good reason to do it. You can't be arrested just because a police officer feels like it. A police officer has to have a good reason to arrest you. For example, if an officer observes a person appearing to steal something, like maybe taking a pair of bolt cutters to a bike lock or something like that, then the officer has a good reason to arrest that person. And if there's not something obvious that a law enforcement officer can observe, like right now, the officer is going to need to get a warrant. A warrant is an official document issued by a court authorizing the search or seizure of people or places or things. So let's say that somebody robs a bank. And there is video surveillance footage of the robbery, and the surveillance footage appears to show a certain person. It's like, oh, that looks like Bob or whoever robbing this bank here in the surveillance footage. Well, the officer or the police, they didn't actually see Bob robbing the bank. There's this video footage that appears to show Bob robbing the bank. They can't just go to Bob's house right now and arrest him. What they have to do is get a warrant for his arrest. They have to go down to a court, and they need to say to the judge there at the courthouse, hey, there's this surveillance footage showing that Bob, or somebody looks like Bob anyway, is robbing this bank, so maybe please go arrest him. Maybe have a warrant to do that. and then the judge says, okay, yeah, sure, here's the warrant, and then they can go down and arrest Bob. And that includes an important point there. Notice that the judge can't issue the warrant for Bob's arrest just because he feels like it. The police officers can't ask for the warrant just because they feel like it. They have to show probable cause. They're going to have to demonstrate to the court that they have a good reason for arresting Bob. So normally, for a search or seizure to occur, unless there is an extremely good reason for a law enforcement officer to make a search or seizure, like right now, because they observe a crime happening, for example, then they have to go get a warrant, and they're only going to get the warrant if they can convince the court that they have a good reason for it. And this warrant must specifically name what is going to be searched or seized. So the warrant can't just say, we get to go arrest anybody we feel like arresting. No, it has to specifically say that this is a warrant to arrest Bob, for example, who we think maybe robbed the bank because he looks like the guy in the surveillance footage. And they can't just go and search just anywhere for evidence that Bob may have committed this crime. They can't just go around the entire neighborhood where Bob lives or go to all of his relatives' houses or something to see if maybe Bob stashed some evidence there, unless the warrant specifically says that this is a place that may be searched. So searches or seizures must be reasonable. Usually that means that you've got to get a warrant before you can do it. The warrants are going to be issued by the court only with probable cause, and they must specifically name what's going to be searched or seized. That's the Fourth Amendment. Then there's the Fifth Amendment. The Fifth Amendment says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So, there's a bunch of stuff here. What's all this about? This is mostly about people who have been accused of a crime receiving a fair trial. So let's look at how the Fifth Amendment accomplishes this goal. The Fifth Amendment says that when people are accused of a crime, first they must be indicted by a grand jury before being put on trial. And cases involving the military may be exceptions. So let's say that Mayor Bozo, that we talked about a while ago, he wants to put his opponent in jail for a while, and maybe he manages to get a warrant for his arrest. Have his pal at the police department get a warrant and do all that stuff. But there's really not a lot to it, and maybe he's thinking though, well, I don't need to actually put him in jail. I just need to make him look bad and have him take a bunch of his time and energy going through this trial instead of participating in the election campaign. Well, the thing is that they can't even put the guy on trial unless a grand jury has decided that there is enough evidence to have a trial. And then the grand jury will indict the guy. An indictment is a formal accusation. So this is a step that happens before a trial takes place. Because why should anybody waste their time with a trial unless there's good evidence that a trial is necessary? If there's no evidence that a trial is necessary, then it's just a waste of everybody's resources. So before someone is put on trial for a crime, They must be indicted or formally accused by a grand jury that has decided that, yes, there actually is enough evidence to make a trial worthwhile. So that's the first provision of the Fifth Amendment. Secondly, people may not be tried for the same crime more than once. Now, this doesn't mean that that if you go on trial once for robbing a bank, and let's just say, okay, fine. So I robbed the bank, and I went on trial. I was convicted. I went to jail, but then I got out of jail. I finished my sentence. Ha ha! Now I can go and rob banks, and they could never put me on trial for it anymore. Yay! No, that's not how it works. That just means that that one time that you robbed the bank, they can't put you on trial for that specific instance of bank robbery more than once. The government can't go, oh, like if they lose the case, if you are declared innocent of the crime of robbing the bank that time, the government can't go, let's try that again, and just tie you up in court, putting you on trial for the same crime over and over again. Can't do that. They basically get one shot. Now, there can be some exceptions to that in some cases, but that's the general rule. People may not be tried for the same crime more than once. That's the general rule. Third point in the Fifth Amendment, people may not be forced to witness against themselves. This is why you might hear sometimes of people pleading the Fifth. So when someone is put on trial, they can be called to the witness stand and they can be asked questions. So, Bob, did you actually rob the bank? Well, now you might think, well, Bob can just lie. Well, he could, but before you are called as a witness in court, then you are required to make an oath or affirmation promising that you will tell the truth. And if you don't tell the truth after you have promised to tell the truth, then you have committed the additional crime of perjury, which will mean that if they can show that you lied, then you're in really, really deep trouble. So, lying is a thing that people do, and it's a bad idea for lots of reasons, obviously. But when you're in court, then there are like extra reasons, even more than normal, to not lie. So to avoid forcing someone to witness against himself, then the Fifth Amendment says that no one may be forced to witness against themselves. So that's why people plead the Fifth sometimes. So, Bob, did you rob the bank? Then Bob can just say, I plead the Fifth. I'm just not going to answer that question, and you cannot force me to answer that question. That's also where the little spiel that police officers give when they arrest somebody comes from. The whole "you have the right to remain silent" thing, that's where this comes from. Because people may not be forced to give evidence against themselves. And then, people may only be punished if the law has been followed. So Mayor Bozo can't take his political opponent and throw him in jail just because he feels like it and say, well, I don't really feel like facing you in the election, so I'm just going to throw you in jail just because, and we don't have to have a trial or anything. No, can't do that. People may only be punished by the government if all of the proper steps have been followed according to the law. Then a person may be punished if all the proper procedures have been followed, but only then. And finally, and I don't know why they put this one in the Fifth Amendment, I guess they needed to put it somewhere, but anyways, private property may be taken for public use only after being bought for a fair price. Let's say that they want to build a highway through Farmer Jones's field, and Farmer Jones maybe doesn't feel like chopping up his field and having a highway built through it. Well, you know what? The government can say, sorry, Farmer Jones, it is more important for the community that the highway be built than that you have your field. So, sorry, Farmer Jones, we're just going to take your field from you and we're going to build the highway through it. Too bad. I'm sorry if you don't like that. The government actually may do that. The government is allowed to do that sometimes. That's called eminent domain is the term for that. But if they're going to do that, they must give Farmer Jones a fair price when they just up and take his stuff like that. So that's what that's talking about. That's the Fifth Amendment. Sixth Amendment, very similar to the Fifth Amendment in some ways. It says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. More stuff. Guaranteeing the right of Americans to a fair trial when they've been accused of a crime. So, Sixth Amendment says that criminal trials must be, first of all, speedy. They can't leave you waiting for it to happen indefinitely as a way of, say, a way of Mayor Bozo taking up all of his political opponents' time and energy by delaying his trial for a long, long time. They must be public. They can't have trials in secret, where maybe if there's monkey business going on that the court is doing, nobody has an opportunity to see it and maybe figure out there's monkey business and expose it. Trials must be by jury. In other words, in most cases, a judge is not going to make a decision about whether or not a person is innocent or guilty. A jury, which is a body of ordinary citizens, is going to make the decision in the trial. So whenever there's a trial, then the court is going to gather a group of ordinary citizens, and they are going to be the jury that is going to decide the case. You might hear sometimes about people going in for jury duty. That's what they're doing. They're going in to possibly serve as a jury to decide a criminal case. And all trials must be by jury, generally speaking. Sometimes there can be exceptions. I might talk about that another time. Also, criminal trials must be held in the region where the crime was committed. They can't have a trial where if the crime was committed here in Pennsylvania, they can't just haul off and have the trial in Ohio or Maryland or West Virginia or somewhere. And those who are put on trial must have the opportunity to know what they're accused of. They have to tell you exactly what you're being accused of so that the person who is accused has an opportunity to confront those who witness against him and say, hang on a second, so you say that you saw me rob the bank. Well, hang on a second though, what kind of shoes was the bank robber wearing? I don't know, I'm just making stuff up. But, he was wearing, the purple and brown shoes. Well, you know what? I've never had a pair of purple and brown shoes in my life, so there. So it must not have been me. And to get witnesses in his favor and say, yep, Bob accused of robbing the bank, he can go and get his pal that he was playing disc golf with and say, yeah, when the bank was robbed, then my pal Bob here was playing disc golf with me, so obviously he wasn't robbing the bank then. And also, those put on trial must have the opportunity to have a lawyer working for them and assisting them, giving them legal advice, and helping them to have the best possible outcome for them. So that's the Sixth Amendment to ensure fair trials for those accused of crimes. Then there's the Seventh Amendment. The Seventh Amendment is about what we call a civil trial. It says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So, just like the Fifth and Sixth Amendments are about fair trials in criminal cases, the Seventh Amendment is about fair trials in what we call civil cases. So this is about a civil trial. A civil trial is a trial in which someone is accused of doing a bad thing that harms someone but is not a crime. So let's say that Billy goes to Joe's house and Billy accidentally throws a book at a mirror and breaks the mirror, let's just say. And he refuses to pay for the mirror. Well, and I got my people mixed up now. I forget if it was Billy who broke Joe's mirror or Joe broke Billy's mirror. It doesn't really matter. Let's say that Billy broke Joe's mirror. Okay, so Joe says, hey, pay for my mirror. And Billy says, it was an accident. I didn't mean to. I shouldn't have to pay for it. And so they get in an argument. Well, Joe can take Billy to court. I'm still not sure. Do I have them mixed up? Well, whatever. It doesn't matter. So this would be a civil trial. It's not a crime to break somebody's mirror accidentally like that, but it is a bad thing that the one guy did to the other guy. So if they can't solve their problems nicely, then they might go to court. When you hear about somebody suing somebody else, it's usually a civil trial like this. And if the amount involved is more than $20, so if the mirror costs more than $20, let's say, then the person accused of the civil offense has a right to a jury trial, just as if it were a criminal matter. So that's the 7th Amendment. Then there's the 8th Amendment. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So this is after you've been put on trial, you've been convicted of your crime. In other words, the court has determined, yes, you did commit this crime. This is about the punishment that you receive. Well, and actually, okay, there's the part about bail. I almost forgot about the part about bail. So let's actually talk about the bail. Bail and fines must not be excessive. What is bail? Well, bail is an amount of money that is paid to a court before a trial to ensure that the person accused of the crime actually shows up for the trial. So Bob is accused of robbing the bank. He's arrested for possibly robbing the bank. He's going to be put on trial for robbing the bank. Now, if you're Bob, you might be thinking, oh man, what if they find me guilty of robbing the bank? I'll go to jail. That would be terrible. I know, I have a bright idea. I'm going to buy a plane ticket to Australia, and I'll just go out to Australia, and I'll go camping forever out in the bush, in the outback, and they'll never find me, and I'll get away with it. Yay! Well, they don't want that to happen. So they can keep Bob in jail if they want to until the trial happens. But maybe that's not fair either, because think about it. You're innocent until proven guilty, right? That's a pretty important concept. So what if Bob is innocent of robbing the bank? What if he actually didn't do it? Then they kept this innocent guy in jail this whole time? What's up with that? So they can have Bob pay bail, an amount of money that Bob is only going to get back if he actually shows up for trial. So in the case of a serious crime like robbing a bank, bail is probably going to be pretty high. It could be many thousands of dollars. Sometimes bail can be, I've heard of bail in the millions of dollars before, although that would be pretty rare. But for a serious crime like bank robbery, it might be in the thousands of dollars. So Bob might have to pay, I'm just making stuff up, let's just say $10,000 bail, let's just say. $10,000, that's kind of a lot of money. And so Bob pays $10,000, and then he can be out of jail until the trial takes place. And then if he shows up for the trial, then he gets his money back. If he doesn't show up for the trial, though, then he does not get his money back. And of course, they'll be looking for him. And if they catch him, well, this is not going to turn out well. Now, you don't get bail all the time because you might think, oh, well, Bob just maybe, what if he really did rob the bank and he hid the money somewhere? And so to him, $10,000 is nothing now. So he's just going to pay the $10,000 and go running off to Australia. Well, a court may determine that they are not going to give somebody bail. If they determine that there's a very good chance, if there's strong evidence that the person really did commit the crime, and if they might determine that the person accused is what they call a flight risk, like there's a good chance of him running off, and they'll say, sorry, pal, no bail for you. You're going to have to stay in jail till the trial. But when they do have bail, according to the 8th Amendment, it must not be excessive. If somebody is accused of shoplifting a candy bar or something, they can't throw him in jail until the trial and set the bail at $1 million or something for a candy bar. That's ridiculous. That would be excessive bail. And if somebody is determined to be guilty of shoplifting a candy bar, they can't make you pay a $20 million fine for stealing a candy bar. That would be excessive. And punishments must not be cruel or unusual. They can't dream up some nasty thing to do to people just because they feel like it. That would be against the Eighth Amendment. And of course, there's a lot of debate about what excessive means, what cruel or unusual means, but the general principle is there. Even when someone is determined to be guilty of a crime, then the government may not do just whatever it feels like to the person. Well, that's it for today. Remember to like and subscribe and follow me on InstaSnap. See ya!